Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We are going to continue with the previous year question discussion for Coal India MT exam. Now the syllabus has changed and various new topics are added. We will add the study notes and questions for all the new topics in our Coal India Management Trainee Legal online course. So if you are looking for preparation material for this exam, you can check out our course. Now in this video, we are going to discuss questions from CPC, Code of Civil Procedure and Limitation Act. The first question is, the power of revision under section 115 of CPC lies with. The correct answer here is C. It lies with High Court. As per section 115 of CPC, the High Court has powers of revision. The High Court may call for a record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or have failed to exercise a jurisdiction so vested, or have acted in the exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order in the case as it thinks fit. Then question number 2. Provision for award of cost is provided in which of the following sections of CPC? The correct answer here is D. Section number 35 of CPC contains the provision as to costs. Question number 3. The second appeal shall lie on which of the following ground? The correct answer here is B. Substantial question of law is involved. The second appeal always lie on substantial question of law and not on the question of fact. Question number 4. Section 151 of CPC deals with. The correct answer here is B. Inherent parts of the code. Question number 5. Mesne profits according to section 2 subsection 12 of CPC does not include. The correct answer here is C. Profit made by a person in wrongful possession due to improvement made by him. Mesne profits does not include profit made in wrongful possession due to improvements. All the other things are included in mesne profits. Question number 6. A decree for restitution of conjugal rights can be executed by which of the following modes? The correct answer here is D. Attachment of property of defying party. This is as per Order 21, Rule 32 of CPC. The court can pass a decree for restitution of conjugal rights and order the erring spouse to cohabit with the aggrieved spouse. Also, under the Indian law, a decree of restitution of conjugal rights can be executed by the attachment of respondent's property. Then question number 7. A money decree cannot be executed against a woman judgment debtor by adopting one of the following modes. The correct answer here is C. Arrest and detention. This is as per section 56 of CPC. The court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for payment of money. Question number 8. Meaning of res judicata is. The correct answer here is A. Rule of finality or conclusiveness of a judgment. The doctrine of res judicata has been defined in section number 11 of CPC. This doctrine means the matter is already judged. It means that no court will have the power to try any fresh suit or issues which has already been settled in the former suit between the same parties. Then question number 9. I think this is a question which has been mistakenly added. It's of Evidence Act. You can read it. The doctrine of res gestae has been incorporated in which of the following section? That is section number 6. We will discuss this again when we are discussing questions from Evidence Act. As of now, question 10. When the court refer parties to suit for settlement of dispute under section 89 of CPC, the plaintiff is. The correct answer here is B. Entitled to refund of court fee. This is section number 16 of refund of fee, where the court refers the parties to the suit to any one of the mode of settlement of dispute referred to in section number 89 of CPC. The plaintiff shall be entitled to a certificate from the court authorizing him to receive back from the collector the full amount of fee paid in respect of such plaint. Then question number 11. The period of limitation for filing any suit for which no period of limitation has been provided in Schedule of the Limitation Act shall be. The correct answer here is B. 3 years. This is as per Part 10, suits for which there is no prescribed period. Question number 12. If a witness resides outside India, the court may issue. The correct answer here is A. A letter of request. This is as per Order 27, Rule 5 of the CPC. Commission or request to examine witness not within India. Then question number 13. Period of limitation is not applicable in a suit against. The correct answer here is A. Against trustee. This is as per section 10. Suit against trustees and their representatives. No suit against a person in whom property has become vested in trust for any specific purpose or against his legal representative or assignee for the purpose of following in his or their hand such property or for an account of such property or proceed shall be barred by any length of time. Then question number 14. According to section 6 of Limitation Act, during period of legal disability, the period of limitation shall, the correct answer here is B, remain suspended. This is as per section 6 legal disability. Then question number 15. With reference to the decree, which of the following statement is wrong? The correct answer here is C. An order of dismissal for default is also decree. Decree has been defined under section 2 subsection 2 of the Civil Procedure Code. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of parties with regard to all or any of the matters in controversy in the suit, and it can be preliminary or final. It shall be deemed to include the rejection of plaint and determination of any question within section 144, but shall not include. So it will not include any order of dismissal for default. Coming to question number 16. If before expiry of period of limitation, an acknowledgement in writing is made about liability of debt and promise to pay, what will be the effect of such acknowledgement? The correct answer here is B. Fresh period of limitation will begin. This is as per section number 18 of Limitation Act, effect of acknowledgement in writing. Question number 17. Section 51 of CPC deals with which of the following issues? The correct answer here is B. Execution of decree. Section 51 talks about powers of courts to enforce execution. Then question number 18. Section 25 of Code of Civil Procedure deals with. The correct answer here is B. Power of Supreme Court to transfer suits on the application of a party and after notice to the parties and after hearing such of them as desired. Supreme Court, if satisfied that an order under this section is expedient for the ends of justice, direct that any suit, appeal or proceeding be transferred from a high court or other civil court in one state to high court or other civil court in other state. Then question number 19. According to section 9 of CPC, the court shall have jurisdiction to try all suits of a civil nature excepting suits of which, the correct answer here is B, cognizance is expressly or impliedly barred. This is section 9, courts to try all civil suits unless barred. Then question number 20. The Code of Civil Procedure as amended contains how many sections and orders? The correct answer here is C, 158 sections and 51 orders. Question number 21. With reference to Limitation Act 1963, limitation period for filing the suit for possession of immovable property based on previous possession and not on title when the plaintiff while in possession of the property has been disposed shall be dashed from the date of dispossession. The correct answer here is A, 12 years. This is as per Article 64 of the Limitation Act for possession of immovable property based on previous possession and not on title. The limitation period is 12 years from the date of dispossession. Question number 22. With reference to the Code of Civil Procedure, upon application of the decree holder, the court which passed the decree may, whenever think fit, issue dash to any other court which would be competent to execute such decree. The correct answer here is C, precept. Section 46 of CPC empowers the court to issue a precept to any other court which would be competent to execute the decree to attach any property of the judgment debtor specified in the precept and lying within the jurisdiction of the court. Then question number 23. According to section 2B of the Limitation Act, nothing shall be deemed to be done in good faith which is not done. Actually, this is not B, this is 2H. The correct answer here is A, with due care and attention. As per Limitation Act, section 2, clause H, good faith, nothing shall be deemed to be done in good faith which is not done with due care and attention. Question number 24. With reference to CPC, in which of the following cases Supreme Court stated as under? There is a presumption that a civil court will have jurisdiction and the ouster of civil court jurisdiction is not to be readily inferred. The correct answer here is C, RSRTC versus Bal Mukund Berwa. You can pause the screen and read this case law, read this judgment. It was stated that the civil court, being a court of plenary jurisdiction, has the jurisdiction to determine its jurisdiction upon considering the avertments made in the plaint, but that would not mean that the plaintiff can circumvent the provisions of law in order to invest jurisdiction on the civil court, although it otherwise may not possess. For the said purpose, the court in given case would be entitled to decide the question of its own jurisdiction upon arriving at a finding in regard to the existence of jurisdictional fact. It is also well settled that there is a presumption that a civil court will have jurisdiction and the ouster of civil court's jurisdiction is not to be readily inferred. A person taking a plea contra must establish the same. Then question number 25. Conditions when foreign judgment is not conclusive are laid down in which section of CPC? The correct answer here is B, section number 13. As per CPC, foreign judgments have been discussed to be not conclusive in certain situations as enlisted under section number 13. Section 13 talks about when foreign judgments not conclusive. Then question number 26. As per section 24 of Limitation Act, all instruments shall for the purpose of Limitation Act be deemed to made with reference to be. The correct answer here is D, Gregorian calendar. This is section 24. Then question number 27. According to section 58 of CPC, every person detained in civil prison in execution of decree shall be so detained where the decree is for payment of a sum of money exceeding 5,000 rupees for a period not exceeding. The correct answer here is B, 3 months. This is section 58 of CPC. Then question 28. With reference to CPC, read the following statements and select the correct option from below. Service substituted by order of court shall be effectuated as if it had been made on the defendant personally. Second, every summons shall be accompanied by a copy of the plea. The correct answer here is B. Both the statements 1 and 2 are correct. Order 5, Rule 2 and Rule 20 deals with both these statements. You can pause the screen, read the options. You can go back to your Bare Act and read these orders. Question number 29. Effect of fraud or mistake has been prescribed in section dash of the Limitation Act. The correct answer here is B, section number 17. Then question number 30. Under section 77 of Code of Civil Procedure, in lieu of issuing commission, the court may issue dash to examine a witness residing at any place dash. The correct answer here is D. The court may issue letter of request to examine a witness residing at any place not within India. Then question number 31. Provision for compensatory cost in respect of false or vexatious claims or defenses was inserted in the CPC in the year. The correct answer is D, in 1922. Section 35E was inserted in 1922. Then question number 32. According to section 2G of CPC, judgment means. The correct answer here is A, statement given by the judge of the grounds on a decree or order. Then question number 33. Order 19 of CPC is related to. The correct answer here is B, affidavits. Then question number 34. According to section 21 of CPC, objections as place of suing shall not be allowed by any dash unless such objection was taken in the court of first instance. The correct answer here is A, appellate or revisional court. Section 21 talks about objections as to jurisdiction, and it says no objection as to place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity. Then question number 35. Right to lodge caveat has been provided in which section of the Code of Civil Procedure? The correct answer here is B, section 148. A talks about right to lodge caveat. So these are all the questions that have come from CPC and Limitation Act. I'm again saying if you need preparation material for this exam, you can check out our Coal India Management Training Legal online course. Enroll with iExamB and make your preparation 50% faster. Thank you so much for watching this video. Subscribe to our channel. Stay tuned.